Let's try that again. Hi, everybody. How are you? Welcome. All right. This is why I don't drink. Thank you all for being here today. It's a couple minutes early, so I just want to say hi. And Apparently I'm the only one here at the moment, but there's nothing wrong with that. Hopefully I'm in the right place. I don't know. I clicked on the button and there it was. Anyway, we are at the Greater San Diego Association of Realtors, and we've tried a new format, and that format is instead of webinars, we're trying meetings. And so there's a bit of a learning curve on it, and that's kind of where we are right now. We're on the learning curve. Hopefully you all can see me, and I know quite a few people have called me this morning wanting to make sure that they get into the webinar. The link that we had takes you to the S.D.A.R. website, and what I'm hearing is that it shows that you have you got to enter in usernames and passwords and stuff. So what I'm going to try to do right now is I'm going to try to actually pull up my screen sharing has stopped. Okay, that's good. Let me see if I can get my email, because I know that a lot of people are trying to get in. I do apologize for that. I will take full responsibility. How's that? Nobody has to worry about who's at fault. I'll take full responsibility. There you go. And nothing yet, so we're not going to worry about it. Okay, so let's go ahead and begin the show. It is 10 a.m. and I want to thank you for spending part of your morning with me, at least. Let's see, I need to go to share. So share screen. There we are. And all kinds of warnings and things like that. And let's do this, and let's go from the beginning. And there we go. Okay. All right. So hopefully that works. I can see it on this screen. 2 people entered the waiting room. Let's see. Unfortunately, that is not. All right. So let's see if I have to enter you into the other one here. So apparently I'm doing host and co-host. So admit everybody. And we'll just leave those all up. Admit all, and let's see if it's going to tell me. Hi, Olga. See if it's going to tell me who all is there. Okay. All right. So I've only been doing these webinars now for about 5 or 6 years. But again, we've been doing webinars rather than meetings. And so, Olga, can you hear me okay? Can you hear me? Yes? Go put your hand like that. Yes. You're awesome. Thank you so much. Thank you. And by the way, I should tell you, this is being recorded and I can see you. So if you don't want to be seen, then turn off your camera, but you can also talk. I mean, that's what's crazy about the whole thing. So I'm going to go ahead and turn on the microphone. I figure, hey, come on, I want to talk to you. I want to hear how you're doing. All right. So I'm going to turn the microphone on, and then we'll have all this incredible feedback. There you go. Okay, so if you have something for me, just go ahead and say it, and I'm happy to help you in any way that I can. I have 3 computers going right now, all of them with this program on it, and so I don't even know which one I'm talking to. But pardon me if I'm rude. So Olga, do you do leases? Do you do rental properties? You do? Okay. Oh, you're muted. Yeah. So you do them. Okay. Do you do property management, or do you do leasing?
No, I'm real estate agent.
Yeah, you're a real estate agent, right? So do you do leases? I mean, do you prepare leases for others?
Yeah.
Okay, all right, okay. So that's what this is all about today. This is not a property management class. I did that last week. But this is all about leasing. So hopefully you'll have some fun. We'll have a good time today. I always enjoy doing it. I always find that I learn a lot more by teaching, because I have to know my stuff. And so please ask questions. If you have a question, please let me know. Okay, so we're at the Greater San Diego Association of Realtors. My name is Kevin Burke. I am a JD. That means juvenile delinquent. or Juris Doctor. I have a law degree, and so that part's good. There's my telephone number, and there is my email address. And so email is usually the best way to get a hold of me. I'm a little difficult sometimes, but I'll give all this information to you at the end again. I prefer to speak with you, live on the phone or whatever. I do a lot of Google Meet, where I can share screens with people and they can show me what issues they're having and things like that. So I'm happy to help in any way that I can. So I have some credentials. I do have a broker's license in California. I've been practicing in California since mid 80s, but I've had a license since 1979. So before most everybody on the call today was born, which is kind of cool. But whoops, here come more people. So joined. Okay. SDR has joined. I have joined. Okay, good. All right. What else? I do teach continuing education for attorneys at UCSD. I used to teach all these other classes, but I decided I wanted to work with people that were actually in real estate and who wanted to do well in real estate, rather than people that were just looking to get 3 hours of credit. So on the right-hand side, I was chair of risk management West for the National Association of Realtors last year. Next year, I am chair of the California Association of Realtors Legal Affairs Forum. And last year, I was chair of risk management and consumer protection. So all that is stuff, as I've said many a time, that is all about stuff that I've done in the past. What am I doing today? So it looks like my email address does show up at the footer. So if you need that at any point, you can always send me an email, stuff like that. Whoops, I got more people coming. Okay. All right. So that being said, we are going to be talking about things that are going to appear to be legal. I am not a practicing attorney. I do a lot of trial work, but mostly as an expert witness. Standard of care is my specialty. For real estate licensees, did the licensees did they do what they were supposed to be doing, et cetera? Agents' duties of inspection and disclosure, and then finally market conditions in San Diego County, although I'm called on across the country to talk about what's going on in the market generally. So our conversation is not intended to be a substitute for the advice of your broker, nor for that of your attorney. Please consult with them as appropriate. You're paying them to be there. And so I really think you need to talk to your broker and make sure your broker knows what you're doing. So talk today is intended to be interactive. Obviously, Olga, you figured out how to use the microphone already, which is really cool. Please ask questions, offer input. You can use the Q&A button or the program itself is set up in such a way now that we can actually do live conversations. So I do look forward to hearing from you. So please interrupt me. If you don't interrupt me, I'm going to start talking faster and faster, which means that I'm going to be more and more difficult to interrupt. So hopefully, you will engage me in this. But and so this is all backwards. We're going to do the listing agreement this afternoon. I thought for sure I changed that. And this morning we're going to do the leases and creating amazing templates. And so is that what everybody has on the calendar for today? We're doing leases this morning and listing agreement this afternoon, right? Okay, good. I thought so. I did that. That messed that all up. So 12 years of college, that kind of thing. So member benefits. So again, thanks for joining us. Residential leases and creating amazing lease templates. Some key concepts. So our subject matter today is residential leasing, not commercial, although I do commercial, not industrial, stuff like that, but it's also not property management. Property management, we'll talk. I want to show you just the difference in it real quick, but you got to check with your broker before doing either one of them. Residential leasing, that means no interaction with the property after the tenant takes possession. And that's the easiest way to remember it. Anything you do after the tenant takes, the link yesterday does not have a webinar link, so I guess many people had trouble joining. Yeah, I know. I get it. I have this great newsletter that goes out, but I was told to put the link in there and it didn't work. And so, all right. So anyway, but thank you, Charles, for being here. So again, so we're clear. Property management, you continue to work with the tenant, you collect rents, you do things like that. But in leasing, after the tenant has possession of the property, you're done. So leasing agent, once the keys are handed over to the tenant lessee, it's over. Is everybody okay with that? I just want to make sure that we're clear about that. You don't answer phone calls about repairs. You don't do repairs. You don't accept rent checks. You don't provide forms, and that's probably one of the most commonly violated things that I see, and that is you get the lease going, and then 3 months later, the owner calls you up and he says, he or she says, you know, the tenant didn't pay the rent. I need you to issue a notice to pay or quit. And the minute you start putting forms in there, now you're doing property management. Is everybody okay? So that's kind of an important concept to remember. And sometimes we're trying to be helpful, but I always say sometimes we can overhelp ourselves right into federal prison. So we don't want to do that. So any touching you do on the property after the lease comes together, that you're doing property management, and the Department of Real Estate is going to have a position on that, which we're going to talk about in a minute. Now, I do a lot of leases. I do easily 100, 200 a year leases. But again, and I have a client that's been doing this with me for 25 years. And you know, I don't hear from him again. When the tenant's ready to leave, he calls me up and says, "Would you list the property again? Let's put it back on the market." And I've been doing that with him for 25 years. He handles the day-to-day. He does all that stuff. Everybody okay with that? So anytime after the keys are delivered normally, and we're going to talk about a couple of forms here today. So boom, 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 leasing versus casual property management. So when you're doing those things I just talked about, even though you claim to be a leasing agent, if you're collecting rents, if you're doing repairs, if you're taking phone calls about things, then you're probably going to be considered by the Department of Real Estate to be doing casual property management, which means it's property management, but you're saying it's not. So they're going to call it casual property management. That means they're going to hold you accountable as a property manager. So most brokerages don't have insurance for property management. There is, speaking of attorneys, hey, welcome. Ramon, I'm sorry. So the California Department of Real Estate has a position on this, and if you make a mistake, you may not have E&O coverage. And so the DRE's position is that if they think you were actually doing property management, then they're going to hold you accountable as a property manager, whether you think you were one or not. And then again, remember what I just said a second ago, most brokerages, the larger ones at least, do not allow property management, and therefore don't have E&O coverage for it. So you want to make sure that you don't do those things. Okay. So again, you do the lease, you're done, everything is over. All right. So as a general rule, doing real estate related activities on behalf of another in California requires a California real estate license. And so today we're going to talk about rental property owner tenant relationships. We're going to talk about the change in terms. So we stopped calling them landlords. Now we call them rental property owners. We stopped calling them property managers. Now we call them housing providers. So we're going to talk a little bit about the rights and responsibilities of the rental property owner, and we're going to talk about the rights and responsibilities of the tenants as well. And I've carved out a little bit of time at the end here that we'll talk about. I want to show you how to create a lease. Actually, we're going to work our way into it really nicely, and so you'll be able to do that along the way. And again, if you want a copy of my lease agreement, send me or my lease template, frankly, send me an email. I will send it to you. So specific duties of the leasing agent, and again, now I'm quoting the California Department of Real Estate, and they say that the leasing agent must advise the rental property owner the rents that will bring the highest yield consistent with good economics, qualify and investigate a prospective tenant's credit, okay, prepare and execute appropriate leases, advertise and publicize vacancies through selected media and broker lists, recommend alterations and modernization as the market dictates. And again, if you're trying to take notes, I'll send this to you if you want it. Inspect vacant space frequently, which I find to be violated quite frequently, that people just don't seem to, follow up on their obligation to actually inspect the property. It just kind of sits there, that kind of thing. Keep abreast of the times and the competitive market and market conditions. Be knowledgeable about and comply with applicable federal, state, and local laws. And I want to just interrupt myself here again for a second. So folks, they switched us from webinars to meetings. I just want everybody to know that if your camera is on, I can see you. And so can everybody else. So, and it is being recorded. So special duties of the leasing agent. So lease agreements. So the DRE, this is interesting. A lot of people don't know this. I know, Ramon, you know this, but Department of Real Estate requires that all lease agreements prepared by a licensee must be in writing. Okay, and that's called the statute of fraud. So an interest in land, in order to be enforceable, must be in writing. And so the Department of Real Estate doesn't want there to be an argument about, you know, he said, she said. So that's why they require us to put everything in writing. And so, and frankly, I agree with them. And so we'll talk a little bit about that in a minute, which clearly sets forth responsibilities of both of the parties. And so what's my leasing agent's liability? And so those obligations, again, quoting the Department of Real Estate, good faith and loyalty to the principal, performance of all duties with skill, care, and due diligence, full disclosure of all pertinent facts, avoidance of commingling of funds. And so commingling of funds is where you put your money in with the money with others. So your tenant, you know, they want to lease a property, they give you the security deposit, and then you put it into your bank account. That's probably going to be commingling of funds. And unfortunately, it'll probably also be conversion of funds, right? For the lawyers on the call today, conversion being that we don't know what money was yours and what money was theirs. So we're just going to assume you're using their money to buy stuff, you know, buy your toys and stuff. Okay. And refraining from personal profits. Now, that doesn't include commissions, obviously, without their full knowledge. So you tell them how much they're going to pay you. You tend to get paid at the beginning, at the inception of the lease, versus property management, where you're paid perhaps monthly. Okay. All right. Agent must be familiar with the laws concerning real estate licensing. That includes contracts, agency, fair housing, property protection, insurance, and tenant rental property owner relationships. So above are the already things that you're required to know to do real estate transactions, right? You all do this already, you know, so you really, this isn't a surprise. You know, the question is, you know, if I would work with someone who's doing leases, or make sure you're in good contact with your broker before you start doing these. But I don't think, I think people shy away from doing leases, and I think that's really sad, because I think if you think about it for a minute, the whole political climate in California right now is geared towards tenants, and part of the reason behind that is that more people are renting than own property. And so if you think about that, that means your pool of clients is greater on a lease than it's going to be on a property on the buy-sell side of things. And so, you know, I always figured my job was to help the homeless. So, you know, I'll do a rental all day long. I had a property I started, I mentioned it earlier, I had a property I was renting. I rented it 25 years ago. And at that time we were renting it for $1,200. Today we're getting $5,800, and that's under market. So just, whoops, somebody else trying to get in, sorry. Sorry, they gave me this button to click on to let people in. And I'm so sorry about that, James. Welcome, James. And James, thank you for your email this morning. We're going to talk about it in a minute. Significant leasing laws, types changing all the time, right? So in San Diego County has their own leasing laws. And I want to show you here new restrictions as of the 27th of May. The tenant protection guide must accompany all leases after the 24th of June. So that being said, I'm going to pull up the tenant protection guide, because I think that's going to be important. So this is the City of San Diego's tenant protection guide. And folks, if you want a copy of this, I am more than happy to send this to you. Okay. So as I have to keep watching my screen to make sure I'm not missing anybody. Hi, Denise. Okay, so and again, as I said a minute ago, they've switched me from webinars to meetings, which means I can see you, and this is being recorded, so they'll be able to see you as well. So if you don't want people to see you, turn the camera off, and you'll be all set. Okay, all right. So tenant protect. This is it, July 2023, and so somebody called me the other day and said, you know, do I have to give it to the tenant? And the answer is absolutely, you have to give it to the tenant. In fact, you have to give it to the tenants for leases that happen. Let's see, down here it'll say anything created after June 24th of this year, you have to give this. There you go. So leases entered on or after June 24th. This applies only if the tenant agrees in writing to end the tenancy, or if the lease expressly allows the landlord to terminate the lease for this reason. So just so you know that this is relating to no fault and just cause, the linchpin of this is going to be June the 21st, 4th. Can everybody see that? Why can't you see that? Why? Because why can't you? Can you all see that?
Yeah.
God, I hope you can. All right. Okay. All right. So that being said, I'll take us back to our PowerPoint. At some point, we're gonna have to make sure everybody can see it, because we're going to be doing some other stuff as well. So, what are the implications of those leasing laws? So when I mentioned the Tenant Protection Guide, that's San Diego. We have the Tenant Protection Act, which is the state of California. And so, what happens if you get this messed up? You could lose your license. You could get sanctions. You could get, do you have to give the TPG document if the landlord is exempt and you provided the written? I can't read the rest of your question. That's something else we're going to have to deal with. Okay, so, and I apologize, everybody. They changed the format on me, and now I'm, so chat, let me see if I can see what the chat says. You have to give the SDTPO document if the landlord is exempt and you provided the written exemption. And so I would tell you that yes, because the exemption that you're referring to, I believe, is at the state level, not at the local level. So when they put the Tenant Protection Act in place, it kind of opened the door for local areas to create their own rules. And I think if you look at that, and again, so is this James? James, send me an email. I will send it to you. Okay, so you'll have it. It reads pretty well. Okay, fair housing, possible federal offense, and we'll talk about a couple of those things here today. Can be criminal, therefore criminal sanctions. And remember, anytime you create a crime, no, it is at the local level. If they're exempt from the local level, then you don't have to give it. Yeah, exactly. So probably no E&O coverage if we break the law. Okay. So again, loss of license, etc. Tenant selection. So we'll talk a little bit about screening. So I think it's best not to require a photo ID until after the decision has been made to lease to someone. That's one of those things. I'm not sure you want that in the file. It's akin to a sales transaction where people send pictures of the family and do things like that. Okay. Potential fair housing accusations. All tenant applicants complete the same application. So you don't give different forms to different people. So everybody, so in our office, we use the tenant screening application, and everybody gets the same form, and every individual gets their own form. Some of you will remember that many years ago, we used to have husband and wife could fill out just one form together, and then wisely, I think we decided that they needed to have separate applications. And so we're going to talk about who needs to be on the lease here in a minute and who you should be getting applications from. Again, it's in your best interest to make sure that everyone fills out a separate application. So credit reports, most of you would know that it is a criminal offense to run someone's credit report without their express written prior authorization. And so when we look at that tenant application form, in a second, we're going to go to the program there. You'll see right on it, it gives you permission to run their credit. So again, federal offense to run someone's credit without it. Have a separate credit report for each applicant. So in other words, separate application for each applicant, but then also a separate credit report for each applicant. Okay. Over the age of 18. So obviously the age of consent or the age of majority. People say, well, they got a daughter, 17. What do you do when she turns 18? I'd probably get her on the lease. I'd probably get an application from her at that time. It may be fairly de minimis for that individual, but again, you want people with at the age of consent to be also have the lease agreement be able to be enforced against them. Okay, so and again, in California, occupying the property greater than 14 days. And so, if they're there less than 14 days, they're considered a guest. And for the lawyers on the call, that we have a difference between a guest and an invitee. So, but if they're going to stay in the property for more than 14 days, then they definitely need to have an application in. They have to be on the lease agreement. And again, make sure that you've given them a separate credit report or separate application form. Don't just let people stay there. We frequently will have people where the one with a really good credit comes in and fills out the application and gets approved for the lease, and then we have the trailing person with the really lousy credit, and so you don't want to have them staying in the property. I mean, I've had people come to me with really bad credit, and I've still taken them. I've taken college students that nobody else would take, things like that. And I found them to be really good tenants, but probably because I'm the only one that's going to rent to them. But again, everybody gets a separate application and everybody gets a separate credit report. Don't run credit on one and not the other, that kind of thing. Okay. All right. I've always said, if you want to understand real estate, the forms will teach you. So lease or rental agreements, think of it as a tree. All forms flow from either of these two choices. Listing side, leasing side, we're going to talk about those. We're going to talk about the lease listing agreement, which is C.A.R. form LL. Let me start pulling some of these up because I want to make sure we have the time to cover them. Here I am. Got to move that down. I have a lot of stuff. While we're on this page, and I don't know, can you see this page? I'm on the California Association of Realtors website. Can you all see that? And so from this page in the upper right-hand corner, I have, obviously I've already logged in. Oh God, here we go. I've already logged in, but here where it says search, when I click on search, I did that earlier because I wanted to pick up all of the landlord tenant information. And so here's my landlord tenant folder, which you will find when you pull this up. Got a lot of really good information in here, especially if you're doing leases, landlord tenant guide for realtors, abandoned personal property, eviction moratorium extensions. I just had an attorney tell me the other day that if someone's been in the property for more than 12 months, you actually cannot evict them other than for non-payment of rent. So I'm researching that. I don't know that I'm convinced, but okay. Some really good articles on pets and assistance animals. So again, if this is helpful for you, I have printed these. And I'm more than happy to send this to you, or you can go to it yourself. You just go to C.A.R.'s website and just type in landlord tenant folder, and that'll give that to you. I also pulled up the new laws for you. So there's a lot of new laws that are beginning. And James, thank you again. Whoops, are you sharing your screen? Yes, I sure am. I don't know why. Can you see that, Denise? I'm sorry. It's a little frustrating with a new format here. I'm clicking on share screen, can see. Click on green share screen button at the bottom. Yep, I did that. No, it's not screen sharing. Okay, I'm looking at it and it says it is. What have I got to do here? I've got the new share button up here. I'm clicking on share. I'll tell you what, let's do this. I'm going to stop the share and then I'm going to restart the share. How's that? I found that works in Google Meet all the time. Participants can now see your application. Does that work? Stop and reshare. Oh, thanks, Denise. I got that one on my own. Can you see that now, Denise? Yes, no? No. Okay. I'll stop share again. It says I'm screen sharing. So again, let me let Boy, I don't know what else it says. Participants can now see your application, and it shows the screen. Yes, no, no, still no. No, James, no. Okay, all right. Well, I'll be damned. I do not know what the solution is to that. Uh, let me see here. Stop video. Okay, I've stopped sharing again. I really want you to have all this, folks. Hit control to select multiple windows. Your screen is loading. Top, it will let you know you are sharing. Yep, it says it is. And whose screen we are sharing. Are you sharing from SDR Education or your Zoom? Well, Denise, I'm on the actual original program. I'm going to bet that let me try it this way. We encountered a little bit of this the other day too. So you're going to tell me that's working, I'm sure. And let's go to CAR's website. And now bingo, yeah. Well, I've got 3 computers going, and again, my fault. I'll take responsibility for it. I have 3 computers going, and I'm trying to just find the one that's working. So close that window. So anyway, I go up here to my search and I type in landlord tenant. I'm going to need to move that over here. Might as well make the computer this one closer, right? So I'm going to type in. Whoops, first my mouse isn't working. Right, here we go. We're going to get this to work. Don't worry about it. Okay, so search. Click on search, and I'm going to type in landlord tenant, and that will allow us to get caught back up to the other screen that nobody can see. So okay, so landlord tenant folder. This is what I'm looking for. Is everybody good with that? I'm going to abandon the other screen over there. Now it wants me to log in. It says doesn't know who I am. Your CAR, you've got to know who I am. Okay, there we go. All right. Did everybody see that? Everybody see that folder, the landlord tenant folder? Roman, I'm hoping you can see it. Do I have you on this screen? You're not on this screen, so you must be in a webinar. Okay. Well, Linda's there. All right. Yes, we're good. Okay, good. Thank you, James. So there's my landlord tenant folder. Again, you can go get this yourself. You just type in the search right here. You just type in landlord tenant. Okay. So now having done that, I also have quite a few other things inside of that folder that I had open on the screen that nobody could see either. And so I wanted to share that with you. And again, I'm more than happy to give you my work product, as we say, leases, and the PowerPoint. And of course, this shows up. Oh, it shows up on the one computer. Your screen sharing is paused, probably because this computer doesn't have the bandwidth to be able to do it. You can't see that anyway. Just so you know, I have switched to this. And then finally, because I did want to show you new laws. So let's pull up new laws really quick, and then I'll show you the new laws. And here we go. Okay, so this should pop up here in a second. This is the new laws, 2024 new laws. Again, I will send this to you if you want it. There's a handful of things in here, and I'm thankful to James who asked earlier today about or actually commented on what I said in one of our previous webinars about the new law that's the new law that takes effect on the 1st of January, in which the limits on security deposits are going to be 1 month. The governor did sign that into law the last I heard, but it doesn't begin to take effect until July 1. So most of our laws start on January 1 on July 1, and that's a new law that he just signed, and I'll spend 5 years trying to find that as well. So anyway, so it's there. Trust me. Okay. I like it when I say that. Okay. So that being said, let's close that window really fast. And while we're on the subject, I'm going to pull up my zip forms program because I'm going to show you how to find all this on your computer. Actually, now my question is, can you hear me? So
Yes, we can hear
I hope
you.
you can hear me because
But yeah, the
the
screen is
microphone is
still.
actually hooked up to the other computer. Yes, thank you, Denise. Yahoo! It's definitely interactive, right?
Yeah, I know that's important.
Well, it's our swan song today. This is our last day of webinars, by the way, for 2023. And so I'm going to pull up I'm going to bypass my template for a second, and I'm going to, bypass the PowerPoint for a moment, and I'm going to pull up the templates. So now here's my advice to you, because here's what's coming on the 18th, the 19th of December. So they're going to issue new forms. I just did the talk on this on Tuesday. They're going to issue, there's one new form, and that's the buyer's homeowners insurance advisory. There are 38 revised forms. Some of those are, they brought back the vacation rental agreements and the business op agreements and things like that. So there's still a handful of forms. So if you are creating in your zip forms program, if you create templates, which is what you see here on your screen, I have templates. So we have a seller listing template, we have a buyer offer template, we have a template that we give to property management companies that we work with, and then we have the leasing template. So when I pull up the leasing template, it will show us what it is that we actually do. All right. Okay. So this is the leasing template that we use. So you have two parts to it. One of the parts is the lease, the listing, and then the other part is the lease packet. And so, of course, when you're doing things live, they just don't always work the way they're supposed to work. And so my folders button is not working, but I do want to go through these with you here pretty quick. So it looks like there's not a lot in there, but once I start opening these things up, there is a lot inside of that. That says that one's muted, but this one isn't. So we're good. Okay. All right. So let's go ahead.
My screen is showing
template.
viewing.
And again, I have several factors to being in doing leases. One of those factors is that I do not have an ongoing relationship with the property after we put the tenant in the property. So you should not be using property management agreements, that kind of thing. But when you do work with the owner of the property, you will probably use the lease listing agreement. And so good. Now things are starting to work, which is wonderful. All right. So if some of you have experience with this new forms and documents, it's really kind of interesting. I'm going to go ahead and X that to give me a little bit more screen. But from my lease listing agreement, I got a handful of things to be thinking about. Of course, at the top here, we changed the name of the landlord to the rental property owner, the RPO. This is our template, so you'll see some information related to me. Remember that your listing agreement must have a beginning and an ending date. One of the new laws clause that is on that document that I pulled up for you a second ago shows that you will not be allowed to sign leases. You will not be able to sign leases or take listings on property for more than 2 years. And I think that's an attempt to try to get, whoops, you got another one coming in. Okay, hang on a second. Coco. That's the other thing I try to do is try to undo that admit thing so that everybody can get in. All right, so anyway, must have a beginning and an ending date. Obviously, you would want the listing agreement to last as long as your broker tells you want it to last, but you want to, I do not exceed 2 years. Okay, that's all. So beginning and an ending date, and then more people coming in. Look at that, very exciting. Okay. And then, so my listing, so obviously the address, we have to have the address, you have to have the subject matter. And then you have your listing terms. So what's the rental amount? That's going to be something that is going to be, what you're going to talk to the owner about, determine what the rental amount is. Remember when we looked at just a second ago, the DRE requirement says that, you've got to be kind of on the stick on that. You got to know how to figure out what the proper rental amount is for the owner. Security deposits, as we said before, security deposits have been an equivalent of 2 months rent for an unfurnished rental, an equivalent of 3 months rent for a furnished rental. That law is
Kevin.
going to change. And so be aware of that. Again, I will send you my new laws if you want it. What type
Kevin.
of tenancy are you contemplating? I think that's pretty obvious. Items included in the lease and the rental. You want to be specific about that. I've had properties that I've handled where, the owner said, I really don't care. It's a semi-furnished property, but then of course something goes wrong with the, something gets damaged or destroyed, and then all of a sudden they do care. So those are going to be, things you want to make sure you put in there. What is included in the lease rental? And then I don't know why we separated it, but items that are excluded. I've had a couple of lawsuits on this where the information that was in the multiple listing service, the agent had put in, but there was nothing in the listing agreement that talked about it. And so, of course, the owner said, I don't know what he's talking about. The agent put that in there, and our purchase agreements at least say that the buyer will not sue the seller for information that's in marketing materials or MLS or et cetera. And so, but we are able to be sued, and that's Civil Code 1088, which says that we can be held accountable for what we put in marketing materials. So in those cases that I had, neither of them went to trial, and part of the reason was because there was nothing in the listing agreement that said that those items were included, even though the agent put those in the listing. So just be aware of that. Just a little sidebar. Personal property that will not be maintained or replaced. Now, some of you remember this was further down in the listing agreement, previous listing agreement. We've moved it up to the front. So a lot of times we see, refrigerators, washer dryers, things like that. They're there, you can use them, but if they stop working, you're on your own, that kind of thing. Additional terms, if any. Compensation, of course, we have to have a paragraph on compensation. Well, actually, we don't even have to have a paragraph because it can be a zero-sum game. I know people that take them for zero, whatever. I threw in some arbitrary numbers. Anytime you receive a fee, anytime you receive a commission, the law requires that you have the bold printed language included. That's the DRE's information. And by the way, it's interesting. I still get offers today where people have the seller paying or they put in the agreement that their buyer or their tenant, their lessee, will pay a certain fee. It has to be accompanied by this language, and that's not in the agreement between the lessor and the lessee, or the owner, the buyer, or the seller. It's not in that agreement, so you really can't create an agreement that way. But people do it, so I just advise against doing that. Chat, hold on a second. And do you have frozen screens? I don't know what that means. Okay, so whatever your fixed term is going to be, you've got to, if you don't put it in here, you don't get it. Okay, that's the point. So either a fixed, remember it says right up here, it says the amount or rate. So amount would be the dollars or rate would be the percentage. And then you would put those figures in their appropriate place. And then paragraph number 3A3, call your attention, 3A3B is going to be what the Department of Real Estate refers to as the safety or the protection clause. And that's where you put in a number of days that you expect to be protected in the event that the owner leases it to someone that you physically introduced to the property, et cetera, et cetera. Courts, the decisions that I've been seeing say that if you don't put a number in there, then the court just assumes that you don't care and that you won't have any protection. Paragraph number C is in addition, the RPO agrees to pay something. I've had owners pay marketing fees, things like that. And then on paragraph number E, we like to put that clause in there. What happens if the tenant purchases the property? We'd expect to be compensated. We expect the owner to represent us. I'm gonna tell you, I'm a little iffy on that clause, and here's why. Because I don't think it's enough to create an agreement on the seller or to obligate the seller. I think you need a listing agreement, something along that line, but who am I to say, right? So, and then on page 2, RPO has been advised of the brokerage policy on how much we're going to pay the other side. And so I get calls daily on the Sitzer Burnett decision, and it's an interesting, decision. It's in Missouri, and in my calls that I've been on with the California attorneys, we pretty much. This language you have right here is not in that language in other areas, and so it's not really clear to the owner that the seller's agent or the listing agent they claim not to have been aware that there was compensation being paid out of the money that was being given to the seller's agent or the listing agent. So California is pretty clear about it. Some of you might know we actually had a lawsuit in San Diego over that subject a number of years back, and it never went to court. So and part of the reason was because of the way that we write our contracts in California. So I'm kind of proud of that fact. What other kind of stuff in here do we need to be looking at? Let's see, no obligation to pay. Yep, you got that. Tenant payments. So the following are due and payable to the RPO. So they go directly to the rental property owner unless otherwise specified. Okay, so if you put your name in there, now you've got to have a trust log, trust account. And these are going to talk about when those monies are going to come over. Okay. All right. I'm not too fond of direct electronic rental payments. Part of the reason that I'm not fond of that is that we have laws in California, our NSF laws, our insufficient funds laws that don't apply to direct electronic rental payments. And so you have some additional protections and certainly some additional recourse with the NSF laws that you don't have whenever there's an electronic payment. Okay. Key safe lockbox. Yeah, you've got to have the owner's permission to put a lockbox on the property. Now, this is going to be separate from when you put a tenant in the property. With a tenant in the property, you absolutely are going to need to have that KLA form, which is the key safe lockbox addendum. And essentially what that all says is that we don't have insurance to cover your toys. And so, you need to get your own insurance. Sign on the property, yes, no. Multiple listing service. Are you going to put it in a multiple listing service or not? Not everybody does on leases. Can someone tell him to update the screen? So this person's on the other program. Man. Okay, so they are logged in. Well, I don't know what to say. They're logged in under the webinar version and not the version that they were given, but you all have figured this out. I don't know how to get them over to this one. Okay. All right. If the people on the other meeting can hear me, we are in the meeting version of it. Send an email to education@sdar.com and they can send you the link to get into the meeting that we're in that shows the actual screen. Okay, security and insurance, I just talked about that a second ago. Ownership, title, and authority, this is very much like what we have in our listing agreements. Let's see here, Denise. So Denise, are you sending me the link that they're supposed to go to? Yes, you are. I see the 0.1 at the end of it. All right, let me see if I can pull that up real fast. Thank you, everybody. I appreciate your patience on this. It's a whole new format. Okay, meeting information. Thank you, Denise. That was very kind of you, because I'm realizing that I can copy paste it right into the chat.
Exactly. Thank you.
Denise, you're wonderful. Okay, so I just copied it into the chat. So thank you for that. You did that help.
Cheers.
Okay, so I put it in the chat to the group that's in the webinar portion of things so that they can come in here and see this. So thank you. Ownership, title, and authority. This is really important. So, when you're doing a real estate transaction, you want to make sure that you are creating a contract between the people that you want to create a contract with. So, a lot of times we take the owner's word for it. I remember having a conversation with the broker for another very large brokerage firm, where we really don't do anything to make people prove that they are the owner of the property. So, what we do is we pull up the tax records, things like that. Linda pulls up the grant deed, my broker, she pulls up the grant deed just to confirm that people are actually the owner of the property. And in fact, it worked really well for us yesterday, where we were doing an agreement, and we saw from CRS tax and from RPR, we saw two owners on the property. When Linda pulled up the grant deed, voila, there was a third owner. So again, it's available through most title companies. That would be my advice. It'd be to do that, but literally it was a husband and wife, and then there was a third person with exactly the same name as the husband, except the middle initial was different. And so when we did a little further research on it with the owner, they said, "Oh yeah, that's my brother." And so it's like, yeah, okay, well, he's on title. So same rule applies to sales as it does here in leases. Make sure you have the permission of the person authorized to sign on behalf of the owner or the owner of the property. And so, paragraph number 9, don't just fly through this real fast. You need to make sure you ask the question of the person that you're sitting in front of or whatever, is there anybody else that's going to have ownership interest or a decision? We just closed a transaction where the neighbor across the street actually had an interest in the property. They had lent money to the now seller. They had lent money to them as a buyer, and now they had an interest in the property that was not recorded. Okay, so for those of you on the other screen that have just joined us, the link is in there in the middle of the chat to take you to where we all are. So, okay, all right. Everybody good with that? The new link still is not working. God's sakes. That is the link I just copied out of the program. So let's try it again. I've only been doing this for about 10 years. Okay. All right. Maybe you share the wrong screen. What screen are you on? Can I even get you to that screen? I'm not logged into that computer, so I can't really get you on that screen. So for those of you in the one where you can't see the screen, we're in this other program, and I have quite a few people on that one. So please try that link again and see if that'll let you in, or give it a shot. And maybe I need to admit you. Maybe that's the problem, but I'm not seeing where anybody is asked to be admitted. I don't have anybody else that needs to be admitted. Okay, all right. Really informative webinar and good content. Thank you for that's nice. Yes, send me an email. I will be happy. Yep, you're looking at the wrong computer. Okay, and I don't know how to get that screen to change. And Denise, that's the link that you clicked on, right, to get in?
Yeah, I was trying to get in through that link from another iPad, but it's showing the
That's
same
the right
thing.
link. So for those of you that are looking at the Zoom screen and not at the contract screen, there is a meeting ID and a passcode that should have gone along with that invitation. Okay, so thank you, Denise, again, because I can copy the invitation and I can go ahead and put that in
It's
there and then let
tricky.
them come in that way. Is that true? They do that?
Yeah,
There you go.
yeah,
Okay,
let's see
so
whether we
hopefully
can
that will help.
use
All right,
the
thank
meeting
you, Denise.
ID.
Okay, so I copied that link, by the way. I went to the website and I pulled up the actual invitation that they can click on, although it does have the right last number. So I don't know why they would have to log out and log back in again. So, okay. Let me see here. Owner representations, we always like to Josh, send me an email because I lose that whole screen when I close this down. I don't know how to get the meetings back. We switched from webinars to meetings, and that's part of my challenge today. So I apologize to you. I will send you the video. I'll send you all of my collateral material as well. Send me an email. I'll send you the whole thing. Okay. Thank you, sir. Thank you. Okay, so RPO representations, we'd really like to know whether or not the landlord is in default or whether the owner of the property is in default. In fact, we have a landlord in default addendum that we provide to the tenant, letting them know that the landlord is in default. Some of you are aware there are federal rent skimming issues that go along with landlords who collect rents and do not pay the mortgages. And so if the landlord's in default, that's probably going to be the case. So we want to make sure, again, it usually applies in the first year, but again, I'm not here to give you legal advice. Tax withholding reporting is an interesting situation. And it's one of the reasons we had to revamp the vacation rental agreements. And so, we have tax implications. We also have TOTs, right? So transit occupancy taxes. We'll probably try to touch on that in a minute, but for right now, if you are taking a listing on a property, you must let the owner know that you are required to withhold certain amounts of the rents if the owner is not a California resident or a corporation. So as an example, we are a California corporation at my office, Linda's office. I don't have an office. We are California domestic corporation, but we also operate brokerages in other states. So in California, we're domestic. In the other states, we are considered a foreign corporation. So again, if we are not a California business, there may be some exemptions to us. Again, I'm not giving tax advice, but you can see that there's a requirement to withhold 7% of the gross payments that exceed $1,500 in a calendar year. And so I can't imagine how you would have a property that wouldn't hit that number. But then they can always also do the FTB is Franchise Tax Board Form 589. That rule is going to apply for the state, the non-resident state, but also on the federal level, and that's going to be 30% of the gross rental receipts again. Okay, so that can be a significant amount of money. So now here you are collecting taxes. Okay, and so that's part of it I have a problem with, but again, this is why we don't do property management. So, okay, if you're property management, then you would definitely have to do that. And I have property management companies that I coach or that I counsel with, and they definitely have to withhold. So, and then paragraph number 12 is one of my favorites, and it frequently gets overlooked. And I'm going to tell you, I had this interesting conversation with Wayne Bell, who was our former commissioner, actually 2 commissioners ago now, because Macaulay's not the commissioner anymore. He said you should write this paragraph out, right? Because this outlines your duties. And that's very important because, again, if you don't have an agreement, then there's an argument as to, that the owner of the property may have some false expectations on what your duty is. And so, again, with the law class that I teach, I have the attorneys and the paralegals write this all out in, this is in word wrap, but they write it all out in paragraphs, and they actually tend to enjoy the assignment, but not until after they've done it. As Mr. Bell said, you know, don't go outside of your lane, stay within your field of expertise. And if you read through this document on paragraph number 12, it says to the owner of the property that this is what I'm going to do. And so if you're going to do something other than that, then you know, you definitely you know, it's going to be outside of what your agreement says. Okay, so be careful that you don't do that. All right. Okay, because you are held to that education required to get your real estate license. And I don't remember anywhere and I teach the real estate licensing classes, and there's nowhere in there that talks about construction defect, you know, things like that. So, but I hear people all the time. I got a very nice email from a property manager. Whoops, there's another one trying to get in, iPad. A property manager who said, you know, I just kind of wish everybody operated at the same level. Essentially, that's what they said. I think that, you know, we want to encourage people to learn new things, but I think there should be an apprenticeship and all of that. Paragraph number 13 talks about agency, certainly something I'm very familiar with. And then when does it terminate? 13F, this is very important. This is in all of our employment agreements now. This is also in the lease agreement. And this essentially says at this point. And so me personally, it's always been that when you deliver the keys, you have given possession to the tenant. And likewise, when the tenant leaves the property, they return the keys, and that has always constituted possession. Could you send us a lease template here to follow? Since screen not working, try it again to reopen, still the same screen. Oh, okay. All right. Let me see if I can do that. Hang on a second here. I appreciate everybody's patience. Okay, I'm going to be logging in for the second time. Hopefully C.A.R hasn't figured that out yet. Then I lose this screen, right? So okay, 1 second, everybody. I'm actually almost there. There we go. There's my lease template. Pull that up. Pull up the listing side of things. Here's the lease agreement. And then I can keep us. This is hysterically funny. I mean, anybody that saw what I was doing right now would think I had like 2 heads. Okay, so what does my chat say? So now the screen is changing. Might work now. Yes, it will. It's going to work now. So, okay. All right. So we just finished tax and withholding. We're finishing off with agency. So again, my paragraph number F, 13F, talks about termination of agency relationships. I have had tenants come to me and say, I'll give you back the keys when you return my deposit. You're right, James, they could. Yeah, they could look it up too. So anyway, I've got it going on both screens, 2 completely different programs at the same time. So it's what I do, right? Fix things. So anyway, just be aware, tenant says, I'll give you back the keys when you give me my deposit. Remember that the owner has 21 days to return the deposit after the tenant has vacated the property. So if the tenant doesn't give you the keys, they have not vacated the property. So that time period continues to toll. At the same time, they might be breaching the lease agreement. You know, they stay after the lease is up, then they become essentially a tenant at sufferance rather than a tenant at will. Tenant at will is a tenant who's there for a lawful purpose. Tenant at sufferance is someone who's there not for a lawful purpose. In other words, not that they're committing a crime, but they are in the property after the lease is expired. They shouldn't be there. So just be aware of that. Notice, and this is one of my favorites, and that is the paragraph on attorney's fees. I spent my last evening on the phone with several attorneys. I do tend to talk to them a lot. Interestingly enough, C.A.R is heading in the direction of having attorney's fees being paid by each party paying their own fees. And that is intended to discourage litigation. And so I think it's a good cause. Again, I have had lawsuits where it was very clear that the attorney was not a real estate attorney, that they didn't understand the laws of real estate. And so just make sure, as C.A.R has coined the phrase now, the Qualified California Real Estate Attorney, the QCREA. Anyway, So now we're going to have people paying their own fees. There's still a couple of documents left that they haven't changed that on, but in an employment agreement, at least they want everybody paying their own fees. That discourages people. I had a lawsuit where they just went out and hired the $750 an hour attorney, not realizing that, you know, most of the lawsuits take years to get to court. Much like the Burnett case will take years to really know what the decision is going to be. All the appeals have been filed, all those things are already done, so they're already in process. Dispute resolution. So, you know, we always want to have a paragraph on how we're going to handle disputes, otherwise known as ADR. And San Diego has a great mediation, you know, REMC across the street from the headquarters. Question in the previous PMA for this is the listing agreement, not the PMA. Agreement asks the landlord to indemnify, define, and hold harmless. Is that language in the new form? It should be, James. We're going to take a look at that in a second. I'm going to get through the listing here. Well, actually, we're not going to talk about the PMA. That's in the property management class. And in fact, I did talk about that last week. I'm pretty sure in that class. I'll take a look at it, and I'm more than happy to send you the link to that as well. So thank you for asking the question. Okay, so dispute resolution. So, you know, listen, I like going to court. It's a fun place for me. It's my sandbox, you know, but at the end of the day, there's no money in it for us. Most of the cases that are filed in landlord tenant disputes and frankly in landlord owner, you know, or housing provider, we call the person handling the lease disputes, tend to find themselves into small claims court. But we want people to mediate, at least attempt mediation first. That's important. So that's what this says, kind of paraphrasing it really quick so we can move forward. But we want them to attempt mediation first. And if they don't attempt mediation, they could risk losing being compensated for their attorney's fees in a subsequent lawsuit. So those are important things. Paragraph number 15B talks about additional terms. And of course, you know, we're not going to make the small claims court subject to the contract because they are the court, right? Unlawful detainers, foreclosures. In California, we do trustee sales. We don't really do foreclosures, but okay, so anyway, we covered that. And then, of course, the advisory. The paragraph number 15C gets overlooked, but most of us that have been in the business for any period of time remember that great big paragraph for arbitration that was in the middle of this. We've taken that arbitration out of all of the employment agreements. So they're still in the agreements between the parties, but we've taken them out of the employment agreements because most of the brokers wanted to go to court, right? And so it's not necessarily that they want to go to court because they love being sued, but it's really more so that they don't want a decision being made by someone other than a jury. And so you know, I disagree with that. When should I use the LL form versus the PMA? PMA is when you're property managing and you're handling the property for an extended period of time, including during the lease term. The lease listing agreement is, in this case, what we're talking about, we're only talking about leases, is for when you take a listing on the lease that you expect to be compensated for and that you expect the owner to compensate you for that representation. So blank screen now, can't see the template. Okay, so how's that? Better? That's weird. Why did it do that? Okay, all right. But James, thank you. It's a good question. So that's one of the distinctions we made was that property management was last week. But again, I'm happy to get, you know, live with you after this is over with. We can chat about it too. So, okay, that, and then of course we have paragraph number 16, which nobody knows paragraph 16 is in there. This was a real problem for me as management with three of the largest brokers in San Diego. And so the Department of Real Estate says that the broker has 5 days to decide whether or not they want to do whether they want this to be their listing, that kind of a thing. And so frequently I would have people come into my office, drop the folder down in front of my desk and say, here, this is closing, you know, I want to make sure I get paid. and I would say, you know, when did you take this listing? And of course, it was a month ago. Well, I've lost my 5 days to decide that I wanted to review it with you before you did that. And so the Department of Real Estate requires that anything material to a transaction be given by the associate to the broker within 3 days. My non-legal advice to people is our contract, and I think, you know, for brokers' contracts should be 1 day, but that would give you 4 days to review it. I know I review a lot of contracts, and I can tell you that, you know, sometimes, you know, you get busy and you don't have time to get to things. So you need to give yourself as much time as possible if you're the broker. I know we have a couple brokers on this call today. So you definitely want to make sure all that paperwork comes in a timely manner. Paragraph number 18, additional terms. All these disclosures are great things. I'm going to show you these in a minute. If you're looking over here on the right-hand side, that bar tells us we're not very far down this agreement. So we still have a little bit to go, and I'm going to speed it up a little bit. So this agreement shall be binding on RPO and RPO successors and assigns. Notice it doesn't say of the broker's successors and assigns, because technically speaking, this agreement is what's called a personal services contract. So if something happens to the broker, then it's all the listings go away anyway. And this is the law in most states, clearly where I teach. And so, but a lot of people don't know why is that not in there. And so the answer is, you know, now if it's a corporation or something else, you know, then obviously corporations never die, you know, things like that. So, okay, time of essence. If anybody wants me to explain that, essentially it means that if it says, you know, 17 days, it means 17 days, right? Not 21 or days or whenever. This is the entire contract. No parole evidence rule. Nothing in there that says, you know, well, yeah, but you said. So you want to be really careful about making statements that are inconsistent with the contract. And I'm going to tell you, the new commissioner who just took over was the head of enforcement for the Department of Real Estate. And I know that she reads these things very closely. Wayne Bell, that I mentioned earlier, he was the head of enforcement for 20 years before he became the commissioner. So I don't think that means that we're going to have more enforcement. I think, trust me, the Department of Real Estate has plenty to do. And I frankly, I love the Department of Real Estate. They've done a lot for me. And I say that because, you know, like my DRE class, my RPA class got approved for 5 hours. My BRBC, my buyer representation agreement, got approved for 3 hours. And so I don't understand what people were having problems with the Department of Real Estate. They were very good for me. Okay, so for those of you watching this other screen, I'm going to move this up. So legally authorized signer. So remember that you know, we assume that the person signing the agreement is authorized to sign the agreement, and that applies to whether or not they are a natural person. If you prick them, they bleed, or whether they are a non-natural person, which is everybody else. So if they are a non-natural person, then down here you would check this box. And because now they're an entity, you must fill in, by the way, darn it, right here. So if I check that box, these fields become available. Okay, so I check the box, now that field is available, and there's a second field, and then down here it says I have to give the name of the trust. So that would be a good place to copy paste. Okay. And make sure that you have, because remember what I said in the beginning, we want to make sure we have a binding agreement between the parties. And if you don't have the actual owner's name, then you don't have an agreement between the parties. And this happens frequently. And I had litigation over where the owner of the property was a trust, and they were sued by the buyer of the property, who sued them personally and didn't put the name of the trust in there. And of course, it got thrown out of court. The buyer had to refile and come back in again. So make sure. Plus, when you're putting this agreement into the MLS, you're letting the world know that you have all of the necessary signatures. So you want to make sure that you have all the necessary signatures, and hence my story from earlier today, where, you know, where we found that third seller that did not show up on CRS tax or on RPR. And so you want to make sure you have an agreement that binds all the parties, because, you know, I'm the buyer's agent, I'm the tenant's agent, and I write an offer on your full price offer on your property, and then it turns out there's somebody holding out who won't sign it because they weren't on the original listing agreement. I'm going to be pursuing a commission. I mean, I say that because that's kind of how the rules work. All right. Okay. All right. So have the right people sign these things. And then moving further down a little bit more quickly now, I have my rental property owner disclosure. And I want to compare the two of these, although I think there's still some adjustments that are going to have to be made to it. But if you look at it, this is intended to be provided with a lease listing or property management agreement and with the lease. And so there's a whole bunch of questions in here. We're not going to go through them all, but obviously you can see from the coloration on it that these are going to be something that only the owner can complete. Go back to my other screen as well. And then when they get down to the bottom, this is the one that the tenant is going to sign. So, let me take you back up the top again, because this is important. So this is the RPOD. The RPOQ is not given to the tenant, and yet the RPOQ is going to show up next. And so I think it can be a little bit confusing, but if you just remember to read the header at the top, you'll see it right there. Intended to be provided with a lease listing or property management agreement and not with a residential lease. So obviously the tenant signed the RPOD, but this is now the RPOQ. So there are additional questions, although I don't think there's that many additional questions, but there are additional questions that are offered here that are between the broker and the owner of the property. Okay, everybody good with that? And then of course we have our fair housing. As you all know, I've said this many a time. It's one of those documents that all I can help thinking is what took us so long to get there. We need to have this. This needs to get laid out. California's got 22 protected classes, and so I just fortunately we're ahead of a lot of other parts of the country that don't have anything like this. So and there are a couple of mistakes in it that I caught, but they're going to fix those with a silent publish. And then I have my California Consumer Privacy Act advisory. Now this got updated December of 22. Okay. Chat, it's great. Finally can see what you see. Thank you, Yuqual. Thank you. All right. But the California Consumer Privacy Act advisory was updated. Make sure you're using the current version. It's very important that you use the current version of the forms, and that's the last of the forms on the listing side of things. Okay, so let me go to. I'm almost reluctant to go back to my PowerPoint. I'm going to hit my back button on both screens. Obviously, back button. Hey, do I get extra credit for this? Unbelievable. And then on your screen, you can see that there are some other forms that I did not include that we just don't have time to talk about. But lead-based paint, listen, don't make that mistake. If the property was a pre-78 build, then use the lead paint disclosure. One of the important things to remember on the lead paint disclosure is going to be the fact that it also applies to a second here. That it also applies so we have the environmental hazards booklet that some of us know are usually provided for by the natural hazard disclosure companies, and so that would include this. But in a lease, you must also have it. Notice up at the top of the page, pre-78 housing sales, leases, or rentals. And so we've renamed the form. It's the LPD form, and it was revised in 12/21. And part of the reason why it was revised was because there have been some what they refer to as the lead paint renovation rules, and that's going to be down here. This paragraph, 6 square feet of lead-based paint in a room, or more than 20 square feet of lead-based paint on the exterior. And that rule took effect in 2010. And I'm surprised how many people I talk with that have no idea that that's been the law for a while. The good news is the website is located in here as well that you can go take a look at. And then for purposes of, this is a mistake I see very commonly made by in both property management and leases and in sales, and that is, you leave these blank. And I really think that there needs to be something in there. Lawyers don't like leaving blanks because it tends to allow for people to fill in things above a signature, which is fraud. But I think they should say NA. It doesn't have to have the owner's handwriting. Well, you want to be able to at least be able to prove that you didn't add it later. I've been called in to testify as to whether or not something was added to a document after a signature. And that's an easy one for me. You don't want that. I mean, that's just not going to be good. And again, the parties can waive it, but they have to waive it in writing if they're going to waive it. And that's going to be, hang on a second here, that's going to be on the buyer or tenant side. The buyer can waive it. The tenant does not waive it. The penalty for not doing this is fairly heavy. So it can be a lot of money, and it's usually per offense. So at the last I saw, it was 11,000, but I'm pretty sure it's at about 16,000 now per offense. So be aware of that. Wanted to show you that really quick. So no answer, and then we're going to go back, and we're not going to save the changes. And I'm going to go ahead and take us over to the lease agreement itself. So this was my listing packet. Now I'm going to click on my lease packet. The older computer, and I apologize, the older computer is taking a little bit longer to respond. Lead only applies to residential, not commercial. That is my understanding, yes. When would I use the LL form versus the PMA? The two seem super similar. Well, they're not. The good question though. The PMA is when you're going to be handling the property after the tenant takes possession. That's the easiest way to remember it. The lease listing form you can use also in property management, but and again, our topical matter today is for when we're doing leases, not property management. Property management, I can chat with you off camera on that if you want. And yes, I do. I agree with you about the defendant hold harmless clause. So here I am in my lease packet. I'm going to click on that link. And again, I will share this with you if you want. Send me an email. You got to be specific. Don't just say send me everything, because I'm not going to remember what I did. But on my lease packet, I'm going to, yes, I have a buyer representation agreement for my tenants. Let's take a look at my application really quick. So I'm going to click it on both screens. Hopefully everybody can see it. Boy, you can sure tell the difference between the speed of these computers. Okay, all right. So here's my application form. Again, section to be completed by the applicant. Separate application to lease or rent is required for each occupant 18 years of age or over. Not all on one form, not both of them on one form. Could be an emancipated minor, so anybody's been in the military or the parents have signed off on that, or it's court ordered, or that kind of thing. You could create a binding agreement. The age of consent would be whatever their age is. And so we don't ask for social security numbers on this page. But again, make sure everybody gets their own agreement. So I'm going to go through here. It was interesting. I was talking to someone the other day who said, can you ask them if they've ever been arrested for a crime? And the answer is no. You can ask them if they've been convicted of a crime, but arrested is something completely different. They're innocent until proven guilty. I always get the resident's history, because my experience has been that and by the way, and this just happened, that the most current landlord for them is probably the one with the highest interest in getting rid of them. So I usually go back 2 or 3 landlords. Because the most recent one is the most suspect. All right, so addresses, things like that. A lot of real estate agents have them fill out the form, but then never follow up on it. I think that's going to be a mistake. Let's go down to page 2, creditors information in case the tenant goes bad. And by the way, I said this earlier, I've had people with really, really bad credit reports end up being the best tenants I've ever had. And I've had people with unbelievable stellar credit reports just turn out to be complete pains in the neck. And so again, in San Diego and in California in general, it's difficult to get rid of tenants. And clearly not just because you don't like them or you don't get along. That's not ever going to be a qualifier, right? The days are very different today than they were before. Personal references, nearest relatives, things like that. Please, let me back up here. I'm trying to keep both screens the same. So paragraph number 8 talks about this is an application to rent only, doesn't guarantee you're going to be offered the premises. I get different schools of thought from property management companies that I work with. Some of them say I handle them one application at a time. So the first one that comes in, if that one doesn't work, we go on to the second one. In sales, we tend to give everything to the owner. In property management, you may, if you have a system, you may be able to get away with that. The Department of Real Estate is really good. If something goes wrong, they're going to go after that. But if it's a system you had in place and something failed the system, then they'll help you correct the system. So it's a little bit different. Anyway, if remember the burn form, and I'm going to show you that really fast here in a second, but the tenant is not entitled to a copy of the lease app of the credit report that you order. You have to, by law, give them notice of where they can get their own credit report, and we have a form for that, and it's the credit report upon denial of a lease. Okay, so you definitely you can give them access. They get a free copy of their credit report. You don't give them your credit report. You have things that are different on your credit report. Now I'm going to tell you something. San Diego's got a really good San Diego Association of Realtors, and we've been using it for years. They have a relationship with TransUnion. It's called Smart Union, and they'll run the credit. They'll do all that. We don't see it. I don't want to see it. I don't want to see their SS numbers, things like that. I don't want those in the file. And so San Diego's program is pretty good. It's Smart Move or Smart Union. It's hard to find, but I think I might have it a link in here. We've been using it for years, and we really like it. So. Thank you to San Diego Association of Realtors for turning us on to that. Let's see here. Again, two screens at the same time here, folks. This is my property information screening fee. So we don't even know, there it is, My Smart Move. And notice it starts with SDAR.MySmartMove. And again, we've been using it and we really like it. It's good. In fact, our whole office uses it when we do leases. But again, they go online and actually complete the application on that program and then report back to the Smart Move. Thank you, Denise. Thank you. And so they complete the application. And we just get a thumbs up, thumbs down. We get to see, what it looks like, but we don't want too much of their personal information. And again, it's the owner's decision, as opposed, James, to property management, right? In property management, you're making the decision, so a little bit different. So, but again, we like the program. There's all kinds of services out there, tenant screening, rent spree. Some of them, if you click on the lease forms in zip forms, it'll before you name the project, it's going to ask you to say yes or no to rent spree, for example. Okay. Screening fee, if you have one. We finally updated the numbers. It was around $30 for the longest time, but as of 2020, it's $52.46 per applicant. Let's see here, scrolling down again. You got to tell them where you're getting your information from. And then, again, we don't like them providing an SS number. Whoops, did I go too far? I did go too far. I do want to show you this form. This is a cool form. So hold on a second. There is your tenant. This is the burn form. And the burn form is the one where you notify the tenant of, the fact that you're looking them up, right? I mean, God, there's so many ways to find out so much information about people nowadays, but this is my burn form. And again, hopefully everybody can see that. I'm running it on two different programs right now, but again, it's TransUnion. And that's the information on that. And that's the end of that form. That's the end of all of that, right? So, okay. So let's go back. I want to cover, this was my, I got 12 years of college, my application form. Good. And I'm going to go back over on this one. Linda says, how come you look so stressed after especially now with the way things are going, but that's all right. Okay, let's take a look at my lease agreement. I'm going to take a look at the lease agreement because I want to go through that really fast. I'm going to click on that, and obviously on the faster computer, it's just smoking fast. We're going to pull it up on this computer. which is a little bit slower, but it's okay. We can live with it. Boom. Okay. All right. Here we go. So we're going to talk about our residential lease or month to month. I'm trying to think. I think we have some changes coming to this starting next week. I broke down all of the new and revised forms. So if you want copies of any of that, send me an email, or you can just go onto the YouTube website and pull up the link yourself, and you can see the video on it and all that. Let's see here. So again, this is the lease agreement. So this would be the agreement you would use whether you were a leasing agent or whether you were the property manager. In most cases, I do have some property management companies that actually do their own, have their own forms created by council. So again, housing provider, that's my, so rental property owner is my RPO. That's the owner of the property. The housing provider is a property manager. So James, I believe that might be you. I guess we're gonna have to come up with another name for tenant, but you know, at this point right now, they're still tenant. And then this is actually one of my favorite forms, and tends to be the one that most people really don't spend a lot of time focusing on. I spent a lot of time on this form. So paragraph number 1, and again, all of our contracts are written, all the paragraphs are standalone kind of paragraphs. The intention behind that is the law of severalty that says that if you know, one paragraph is held to be invalid, the rest of them shall still be invalid. And so that's why we do them this way. So in paragraph number 1, we talk about the property itself. We talk about who's going to be in the property, and we're going to want to have those people named. And again, why do we do that? We do that because we want to make sure that we have the names of all the people that are going to be in it. And this is going to lead us to what happens if they bring somebody in who stays more than 14 days. It gives us the right to maybe perhaps eject them from the property. And then again, it's you see it in the agreement again, guests are not permitted to stay more than 14 days without housing providers' written consent. And that's just kind of the way the law is, but obviously you can adjust that. And then personal property, as we saw in the listing part of things, the personal property that would be included, I would recommend that you give them a list, or that this be complete, you know, from what you had on your listing agreement. If you are not the seller's agent or the owner's agent, and you are the tenant's agent, then you would need to make sure that you asked for a list. Okay, so I actually had a transaction that I handled this property for these people for years, and they said, we don't care about the personal property. Well, they had a jade chess set, and so, you know, sure enough, one day they came to visit the property, and again, I've been handling this for 15 years. And these people have apparently been, you know, using the golf club to take the head off the king and the queen. And so, you know, they were really upset about that. And I said, well, you never mentioned that it was important to you, and you certainly didn't put any writing, and you told me that it wasn't important. Well, they ended up going and hiring another property manager because they were unhappy with that simple aspect of things. But you know, and I appreciate the fact that those were probably expensive pieces, but essentially I took the hit, no pun intended, for it. So personal property that's going to be included but not maintained. And then finally, is the property subject to local rent control ordinance? And that's something you're just going to have to look up for each property. Term of my agreement. So again, it doesn't have to be that it is a long term. We're going to start off with a commencement period, and that's the date that it begins. So not the date of the lease, but the date that it begins. Now, be really careful about that, because you know your tenant will say, well, I want to start on the 1st of the month. And then, of course, the 1st of the month is on. So, example, January 1 is Monday. And so then you get that phone call that says, you know, can we move in on, you know, it's the holiday weekend. Can we move in on Friday? You know, the 29th of 29th of December. And the answer is no. And part of that is that you don't have coverage. So remember that if they're in the property without a lease, then you don't have a legal relationship with the tenant. And so, you know, my advice is not to let anyone in the property until the lease begins. So they need to take that into account when they say, I want it to start on the 1st of the month, you know, rather than, okay, you know, the 1st of the month is a Monday, and so we'll give you the keys on Monday, but we're not going to give you the keys on Friday the week we're if you want that, then we're going to have to amend the lease agreement. Is everybody good with that? That's a very important concept. So whatever your start date is maybe not necessarily the agreement date, but I would not be giving them keys unless you have the lease is actually begun. Okay, then you could have month-to-month tenancy, and I'm beginning to so for us in real estate, we tend to charge on leases now. We tend to charge on gross rents. So that tends to lead people to insisting on leases, long-term, 1 year, whatever leases, when in fact it may be more beneficial for the owner to have a month-to-month tenancy. I would have attorneys come and talk at my property management class at the college, and they would come in, and Kathy Belleville, and I loved Kathy, she was great, and she says I don't put any of my tenants on a lease. And she says, because I want to be able to get rid of them in 30 days. And so, today it'd be a little bit harder to do. I'm sure she would, she retired, and I'm sure she'd be capable of doing it, but all her leases were month to month. And so, so there's advantages both ways. Don't just assume that, how you get paid is the most important part of it. But if you're doing month to month, then you might not be entitled as the agent to get paid for each of those months. Because they're probably going to expect you to do something during those months as well. And then under my, and again, make sure you have a termination date and a termination time. And then we have our rents. And so paragraph number 3 discusses the rents. And so it as well as a standalone paragraph. There we go. And so tenant agrees to pay what per month. So now remember, this is a lease, essentially a lease for term. So, if they're signing it as a year's lease, then the owner accepting the rent payments on a monthly basis are considered an accommodation. So, but if this is one of the reasons behind the tenant lives there for 3 months on a 1-year lease, and then at the end of 3 months, they decide to vacate the premises, they owe you for the other 9 months. So you still have a duty to mitigate damages. You have a duty to try to find a same or similar tenant under same or similar circumstances. But I'll frequently have it where I'll have 9 months to go on the lease, and then I'll have I have to advertise it for what the tenant was paying for it. But in order to be able to get that finance from them, get that money from them. But if I offer it for lease for more money than what they were paying, then I won't be entitled to hold them to the vacant period of time that the property was vacant. Okay, so lots of really interesting things in there. So rent is payable on the 1st. That just tends to be the way that it is. But let's remember that if the commencement date falls on a day other than the 1st under 3B, right? Then the tenant has paid 1 full month's rent in advance of the commencement date, the rent for the second calendar month shall be prorated. So I just had this happen with a property management company. They charged the tenant. The tenant moved in the middle of the month. They charged 2 weeks rent rather than 2 weeks plus the next month. And so sure enough, they got the 2 weeks rent, and then the 1st of the month, no rent. So there hasn't been any rent. So so now they're having to litigate over what they got was only 2 weeks worth of rent. Okay, all right. The final part of that sentence is essentially rents are calculated in these types of transactions are calculated in what's referred to as a banker's month. A banker's month being 30 days. Tenants will come to you and say, it's February, you owe me this much more money, on the recovery of my rent, when in fact, it's whether it's 28 days or not, it's considered 30 days on the contract. So, okay, payment. How are you going to accept payment? So this is kind of important. In most cases, personal check is fine. If you decide you want to do electronic payments and things like that, that's kind of on you. Again, are you going to accept rents via Venmo and what's this other one? Here it is, PayPal or Venmo. And so by default, no. And then where are you going to have the rents go to? You got to give them a place to send it. I'm going to tell you, even if you're having it wired. And then paragraph number 3D3, which is down here, is what happens for that NSF. Well, again, you're not going to have an NSF on a electronic payment. You're essentially going to have just no payment. So so you have some things that are available to you if you're accepting checks. A caveat on that remember that if the tenant gives you, let's say, what do you got? You got January coming up. Tenant sends you 3 checks. They send you January, February, March. Remember that the January check is considered subject to NSF. The February, March are not. They are considered a promissory note, and you have to sue them under a different theory of law. So I always tell people, don't send me 3 checks for 3 coming months. What happens if the tenant sends you 3 months in 1 check? Well, that's better, but remember that if something happens during that 3-month period where they're lawfully able to leave the property, then you may end up having to refund them that amount of money. So I had a couple of gals with me who I'm dating myself, but a couple of female Marine Corps helicopter pilots. They were sisters living in a property I owned in Del Mar, and they were with me for years. And then all of a sudden, one day, they reached out to me. They said, "We just got orders," and I said, "Thank you for your service." So if they had paid rents in advance, I would have given all that money back to them, not a problem. But just be aware, there can be situations where the tenant is entitled to a refund of the money that they gave you. So in that situation, it should be, that's your Service Members Relief Act. I would definitely not get into an argument about that. And certainly because it's absolutely unpatriotic. Let's take a look at paragraph number 4 really fast. Security deposits. I've talked about this already a little bit. In leases, which is what we're talking about here today, yes, okay. you can, I don't know what yes means, but okay, all right. Security deposit, again, how much is that going to be? Until thank you, James, until July 1, you can collect an equivalent of 2 months rent for a furnished or unfurnished rental, an equivalent of 3 months worth of rent for a furnished rental for a deposit. We'll discuss pet deposits in a minute. I want to make sure I cover that before we leave today. And then again, security deposit shall not be used by tenant in lieu of last. Never use the words first and last. That's what gets us in, kind of messes us up, because the tenant then thinks that when you're charging them first and last, that they don't have to pay rent the last month, and so that just creates a problem. So I tell people never to use those words. And then down here, within 21 days after the tenant vacates the premises, again, that's when they hand you the keys, you must give them their deposit back or an accounting thereof. Okay, so you either have to give them back their security deposit or an accounting thereof. And remember, there's also this little pre-move out inspection requirement that you go in there 14 days prior to them moving out, and you go through the property and you show them what it is you're going to ding their deposit for. Those are going to be requirements as well. So make sure you give them their 14-day notice. Whoops. Sorry, folks, running 2 different screens here. Some of this we're going to skip over. This is my little grid. I like my little grid, but I shoot. All right, don't do that. But I want to talk about security deposits. And so I've had situations where I've had 5 tenants. I want 1 check. I don't want everybody paying a separate check for rent. I want 1 check for the deposit. You all figure out who the ringleader is, and then you do that. But the problem that you encounter when you accept more than, when you accept a check from each individual, is that they're led to believe that they're no longer jointly and severally liable for the lease. And so, I paid my rent. The other 4 people didn't pay their rent. Go after them, right? So you're gonna have some real problems with that. So I always get 1 check from everybody. Let's see, there's something else in here that was important. And by the way, I give them 1 check back. Unless they send me a writing that says it's okay to disperse, this way or to that person or whatever, then I'll change things. But I want an agreement from all of those people. This little grid is kind of cool. You fill that out as appropriate. There's a box underneath it that says what I just told you a minute ago, an equivalent of 2 months rent for unfurnished, et cetera, et cetera. Watch out for the advanced rents. I did have a tenant. My owner was a judge. And I had half a dozen properties of his, and the tenant had just been evicted from a property down the street, and this is on Mango Drive in Del Mar. and they'd just been evicted. They had an unlawful detainer on their credit report. And I said, why would the judge rent to you? And they said, well, I said, why did you let an unlawful detainer happen? And the response was, it was the principle of the thing. So, I really wish I had $1 for every time somebody said that. The principle of the thing, right? Well, it smelled like cat urine or whatever. And I said, well, you let it go all the way to a UD. So anyway, this tenant offered to pay the entire year up front. Now, watch out for that little caveat in there. And did I change it already? I think I changed it already. That little caveat that says that you can collect advance rents, but it has to be more than 6 months, because anything short of that, they think you're just trying to squirm around the 2 months rent requirement. So I don't understand the logic behind the new law that's coming out that says you can't collect more than 1 month's worth of rent. I think that's going to really disadvantage people that are renting furnished properties. I think we're going to see that maybe hike the rents up, just because they want to get, hike them up even more than they already are. But it is what it is. Late charge return checks. So there is no grace period at law in California for rent. The rent is due on the day that the contract says the rent is due. A lot of people believe that it's 5 days afterward, and that is not true. So, but the default language in the agreement, as you can see, says 5 days. So it says it's not going to be considered late unless if it's received after 5 days after the date it is due. And so that leads them to believe that there's a 5-day grace period. So I have this conversation with my tenants, and I want to be careful everybody's listening to how I'm saying this. So I always say to my tenant, the rent is due on the 1st, I serve you on the 2nd. And I say it that way, and I look them in the eye, and I tell them this is how it's going to go. And you know what? I never have a problem with tenants. I've had tenants stay with me 15 years. I've had tenants stay with me, move to other properties that I own just so they wouldn't lose me. But I'm honest with the tenant. And by the way, when the tenant has anything go wrong with the property, I'm in there fixing it right away. I mean, I'm having somebody else fix it. I'm not going to fix it. But so be good to your tenants. But also be clear. We all need guidelines and things like that. And so that's my opinion. You have allowances for rent due. How much can you collect for late rents? And then NSF fees are limited by statute. And then parking. So you have to tell them whether or not parking is included. Interestingly enough, not as big a deal up in North County, but certainly more of a deal downtown, right? So is parking included? And if it isn't, is there a charge? We just did a transaction where the owner had 2 parking spaces. One of them was deeded to them. The other one they were renting from the homeowners association for $100 a month. So make sure you put that in there. Otherwise, you're going to end up paying somebody's parking. Storage, same kind of rule. Utilities, hang on a second, catching up with the second screen here. Utilities, who pays for what? And then we get into the sub-meters and things like that. Now here's the thing to remember on this. The agreement says tenant pays for all utilities, but I doubt they're also expected to pay the HOA dues. So utilities and HOA dues are 2 different things. So if you're gonna, you want to be clear about that, you might want to put that on there. Water sub-meters, if any, gas meter, if any, electric meters, et cetera, et cetera. Paragraph number 10 talks about one of my favorite forms, which they had to make a correction on. I noticed that there were some misstatements. So the old MIMO, move in, move out form is no longer. Now it's the move in form, and then it's also the move out form, 2 separate forms. They used to be included on the same form, and I guess that confused people. I think it'll go back to that. But in the meantime, make sure your tenant lets you know everything that's wrong with the property. Give them 3 days. That's plenty of time, right? While they're moving in. But they need to let you know what is wrong with the property. If they don't fill it out, then you need to send a writing that says we assume that everything is fine because we didn't hear back from you. But the bottom line is that 6 months from now, they break something and then they say that's the way it was when they moved in. So you need to make sure you're providing them with that form. Make sure you're getting that form returned to you in the proper manner. Maintenance, use, and reporting. So we'll get down here. I may have to skip over that. Who pays for the watering, for example? I tend to, in my houses, I tend to pay half of the water bill. That way the tenant doesn't defeat the rain bird, things like that. So I'm kind of a big in being nice to the tenant because, water, my water bill in Del Mar is my house is $385 a month. So it's not a small water bill. So my tenants, when I have tenants in it, are paying half the water bill and I'm paying the other half of the water bill. And I show them the water bill as they're moving in. So that's usually a very big deal. Neighborhood conditions, I always tell people to make sure they go, when do you sleep? Well, I sleep, from 9 p.m. until 4 a.m. or whatever. Okay, so I think you should really stop by the property before you move in just to make sure that there's nothing going on in there that's going to, like there's a rock and roll band that kicks in every night at 11 o'clock. Stop by the place, see what's going on. My house has, trains in front of it. It just is what it is. Helicopters, it's just the way that it works, right? So I tell them everything. So animals, and again, we have a really good form now. The new animal terms and conditions addendum replaced the old pet form. I really like the form. We're not going to have time to really discuss it today. Smoking on the premises. Again, the default language says no smoking on the premises. I think we're trying to cure all these cancer things, but you could always have an exception up here. Rules and regulations. Now, that's going to be, it could be that the community has rules and regulations, but the owner themselves might have rules and regulations, and they have to provide those to the tenant in a timely manner. Paragraph, that's 15. 16 is a common interest area that has its own rules and regulations. I like to give those to the tenant at the time of the lease agreement. 17, alterations and repairs. Do not repair anything or do anything without our consent. Do not paint the walls purple, things like that. Keys and locks, we're going to give them to you upon commencement and no sooner than that. I don't know why you would check the box that says prior to commencement, but people do it. So, okay. And then give them a list of what you're going to give them. I have them sign a picture of the keys. I put the keys on a countertop. I take a picture of them. I have them sign the picture. Okay, because I want them back, right? So the common area key, frequently Medico keys, I mean, they're going to be a minimum of $250, and I don't want to have to eat the key, as we say, okay? Entry, believe it or not, the owner has the right to enter the property. It is their property, but they have to be reasonable about that entry. I had a complaint from someone who said that the owner was coming in on a daily basis, hypothetically, to check the smoke detectors. I think that's going to be unreasonable. But remember, you also need to have an agreement with the tenant in showing the property. The law says that 24 hours is reasonable notice. My agreement, my addendum with the tenant says that reasonable notice shall be 4 hours by phone. And we're coming in, that kind of thing. So you can make that stipulation. Usually a lot easier to enforce if you make that at the time of the lease agreement rather than waiting until some other time. Photographs and internet advertising. If your stuff is in there when we're listing the property, then we're probably going to have your pictures on the internet. Signs. Tenant authorizes us to put up a sign. Assignment is subletting by default. There is no assignment of subletting in our contracts. And that applies or does not apply to short term. I've seen some real challenges with VRBOs and stuff, not to single anybody out. Joint individual obligation, joint and several obligations is something I talked about earlier. Everybody has to understand that you're all equally responsible for the property. And again, that's why I said I don't want to break with that theme. I have the lease, I have the rent payments, I have the deposits, all going to follow that same thing. Under possession, believe it or not, I don't have to give you the property until 5 days after the lease begins. So it's a little surprise to some people, although I've never really had to exercise it personally, but I've had it happen where tenants had not moved, the previous tenant had not moved out of the property. And then obligations upon vacating. And this is a good place where I put in, that the property shall be returned in professionally cleaned condition. Remember, the law says that they must return it in broom clean condition. So unless you have an agreement to the contrary. And so my lease agreement is going to say professional with receipts, because that's how we give it to them. And so we expect to get it back that same way. Okay. And if you're not giving it to them professionally clean, I think it's unreasonable to expect them to do that. Paragraph 25C talks about that right to pre-move out inspection I discussed earlier. And again, there's a separate form for that. Breach of contract, early termination, one of my favorite things. Usually I don't get the phone call until somebody's angry about something, and usually it's not even my agent. So what happens? And we've talked a little bit about that. Temporary relocation. So, for example, you had to have the house bagged or something. You're gonna give them a credit equivalent to the per diem that they were paying. If it's a 3-day bag, you're paying for 3 days of their rent someplace else. Damage to the premises. I've seen damage exceed deposits. And so remember that they can also do, what's called criminal mischief. So that's going to, the deposit is, the recovery is not going to be limited to the deposit. So, oh shoot, we didn't talk about pet deposits. So, darn it all. I hate it when it does that. Okay, hang on. Don't want to lose you. Okay, damage to the premises. Insurance. I like this. We're requiring tenants to have insurance. So I think that's an important thing. We want the insurance to protect the owner, the property, and to protect us if we're doing property management, right? Okay, so we want the tenant to have insurance. Do not let them move in until they have provided you that proof of insurance. I see this happen. I've got cases on it now where, they don't give you everything they said they were going to give you. And now what do? You're going to evict them over that? And I think the answer is yes, you're going to evict them over that. Water beds and portable washers. Yeah, we're still on that kick, even though water beds really, if you know anything about them, they don't do much more, have much more of a weight displacement than a refrigerator has. Waiver notices, you got to put in places for notice for people. So the housing provider, where do you want service of process? The tenant, almost always in the property, but if they want another place, you got to put that in there. Tenant estoppel certificate, I have such a big thing about that. Absolutely have the tenant fill out the tenant estoppel certificate at the time of the lease. If your owner goes to lease the property or sell the property or lease it to someone else, you want proof that the tenant has what the current tenant's lease agreement says. Remember your TOPA form if you're doing sales. Yeah, your TOPA form is required in the transaction where there's a tenant occupying the property, and that TOPA also has within it the TEC form, the tenant estoppel certificate. I strongly encourage you to make sure that you get that from the tenant, completed by the tenant within 3 days. That's what your lease agreement says. Representation, this is who represents who. And then the tenant is being truthful about what they're doing. Here's my mediation clause again. Wrapping that. I think I'm almost going to get done here on time. Look at that. I am going to get done on time. Attorney's fees. Now, this is a kicker. Look at 36. Attorney's fees. Now, they've done, this is in the last couple of iterations of this, but the attorney's fees provision on the lease between the tenant, the lessee and the lessor, says that the attorney's fees shall be limited to $1,000. I like that, actually. It's kind of interesting. I mean, really, because you're talking about a lease that really shouldn't get out of small claims court. But anyway, it's interesting. I haven't seen any challenges on that, but it is what it is. Then I've got my disclosures, and those. So for those of you looking for things like Megan's Law disclosure data or database disclosure, it is included in this agreement. And so remember, the law says that you must notify the tenant of the existence of the database. My advice is to never go to the database yourself, especially if you're on the database. It's against the law for you to go to the database. It's a $1,000 criminal penalty for doing that. I don't know why you would go. I mean, maybe to look to see if they got the best picture of you or what, but or best mugshot. But you have an obligation to tell them about the existence of the database. I would personally never go to the database only because I don't want to be held accountable. The tenant says, well, the neighbor was on the database and you didn't tell me about that. It's like, well, I didn't know. And they say, well, how come it's on the database? Have you been to the database? And the answer is no, I've never been to the database. But if you'd been to the database, then your answer would have been, I went there last week. And then the tenant's going to say, well, they were on the database last week. Why didn't you tell me? And so, listen, I'm very familiar with the deposition process. It's not one that I wish on anybody. It's a lot of stress. Residential environmental hazards booklet. So again, we're used to seeing those by the natural hazard disclosure companies in a sale transaction, but it is the law. So make sure that you are checking that box. I'm going to pull that up here in a second, and I'll show you where we actually have it as a separate part of our template. Flood hazard disclosure. If you go to that TFHD form, it actually gives you the link, and San Diego has it on their website, and you can pull it up. We have the tenant sign off on it. The form itself says that the property is not in the tenant flood hazard zone. I'm talking to CAR about having that switched, because I think it should say that it is in the zone, because if you tell them it's in the zone and it's not in the zone, probably no lawsuit. But if you tell them it's not in the zone, which is what the default language says, and then it is in the zone, then there is a lawsuit. Okay, so what else? Anything else in there? Service Members Civil Relief Act, I talked to you about that earlier. Time of essence, just like our other stuff. Agency confirmation. And then again, look at my paragraph 41C, termination of agency relationship. Again, same thing. Keys going in, keys going out. That's the way I like to handle it. Remember that the law requires that they have a right to receive their agreements in 5 languages: Spanish, Chinese, Korean, Tagalog, or Vietnamese. Unfortunately, we stopped printing those forms. I asked Gov Hutchinson about that, and he said, "Oh yeah, got rid of that about 5 years ago." And the answer to why was because nobody was ever using it. Okay, so I think that's really, what did I say I was going to go back to? I was going to go back to the my template. I'll take you back to my template. So let me see. So we have same thing: legally authorized users, etc. They're also they have a right to an interpreter. I would recommend against you being the interpreter, but I hear people do it. It's like, I probably wouldn't do that. You don't want to be the interpreter if you have a vested interest in the outcome, right? So entity tenants, entity housing providers, and then we are into I'm gonna call it a wrap. These are all the forms that go with it. But let me go back. I'm gonna go back now to the show you my template really quick, folks, because I know you're all we're at the 2-hour mark here. So PET, Denise, yes, it was the PET. It was called the PET form. Now it's called the ATCA form. Good form. I like it. I like the new form. Okay, so for those of you that are looking at this on the faster computer, you can see over here on the left-hand side my environmental packet. And again, I'm sensitive to your time. Hang on a second. The slower computer is coming up with the information. And it's going to be under, there it is right there. You can see that, the environmental packet, and then it pulls up items, 1 through 6. Again, those are available up here in the libraries, and you can just pull those up. Those are going to be my, going to fall in under my EPUBs. So I go here and I click on EPUBs, which I have conveniently moved to the top of the queue. And then we'll see all of the forms. There they are. I've checked them all. Okay. Questions about any of that? Some of you, I'm going to go back to my PowerPoint, which some of you are not going to be able to see. And we're going to go to, just because I want to show you a couple things really quick. So from current slide. And it's taking me back to the beginning. So we're going to go all the way down here. And I don't know, new share. Oh, I can probably do that over here too. Oh, look at that. There you go. So we talked about listing lease agreements, etc. Hang on a second. I'm going to go lease agreements. Good. Done that. Good faith and loyalty. C.A.R. eliminated the short-term leases, and it's because that we were having issues with owners not paying TOTs and stuff. Trying to catch everybody up to the same page here. Well, we won't do it this way again, that's for sure. This is my second to my last class, by the way. This afternoon will be the last class that I'm doing, last webinar. I don't know what we're doing after that, if anything. I haven't heard from anybody. So, but I am happy to share everything I do with you. Creating templates. Oh God, I told you I was going to create templates. Okay, I'll tell you what, send me an email. I will send you my template. Everybody good with that? Send me an email.
Yes.
I will send you my template. and I will even send you instructions on how to put it together. Okay, and then I will help you. All right. I do have all these go up on the YouTube website. Here's the QR code. Here's at Burke Real Estate Consultants Inc. Case is important. You can just type that into your browser. You can go to bit.ly. I had to learn how to do all these things because we had a changing of the guard, so to speak, at the association. So, but it was kind of fun. I got to learn a whole bunch of neat little things in there. So I was able to do that. And then let me see. You can also go to, please remember to like and subscribe. Subscribe will give you the updates as I put them in there. And then there's my newsletter. If you want to know where I am, where's Waldo after today, that's where it's going to be. So anyway, that's my thoughts. I got you out of here. It is 12 o'clock. I want to thank you all for being here. I very much appreciate the value of your time. I apologize for the technical aspects of what was going on. But if there's anything I can do to help you, please let me know. I'm available for you essentially whenever. I will load this up on the YouTube website later today. And then I will be back at 2 o'clock where we will be talking about the ultimate listing agreement. That's going to be kind of a fun one. I'm probably going to try to use a different computer on this. Again, I don't know why some people were able to get in and some people weren't, but I'll keep the link handy just in case. So thank you all. I wish you the very best. I appreciate the value of your time. And as I say from my hometown of Del Mar, I look forward to seeing you around the track. Thank you, everybody. Take care for now. Bye-bye.
Thank you, Kevin. Bye.